people nearby. That's what, that's how it came out. Ms. Bennett never agreed that there were people nearby. That was Ms. Love saying that. And then it became just communication of what was said there, and Ms. Love somehow made Ms. Bennett feel so uncomfortable Ms. Bennett wanted to harm herself. So you have that series of questions on the courtroom bench. In addition to that, Ms. Love said, "Isn't it true that I communicated with you via telephone at various times?" This is during the, I'm not sure which day, but I believe it's the second day on resurrection. And then Ms. Love said, "Isn't it true that I called you to check on you, on how you were doing?" These are quotes, Your Honor, from the video. I'm not saying from the court report. "Isn't it true that I told you I wanted you to speak with our victim witness advocate at this office? Isn't it true I asked you about Jeffrey Williams while we were in the Wendy's parking lot? The Wendy's parking lot had Investigator Randolph with them. I have no idea what Investigator Randolph heard, what notes he took, etc. Isn't it true that I asked you whether Mr. Anderson," said Michael Anderson, "and Jeffrey Williams were friends before Anderson in 2013? Isn't it true you never once said that Anderson did not occur? Isn't it true I came outside, sat down on the bench next to you? Isn't it true I asked you how you're doing? Isn't it true you told me you were beginning to feel like you wanted to harm yourself again? Isn't it true I asked you what caused you to feel this way? Isn't it true you told me you, Miss Love, you are the reason I'm starting to feel this way? Isn't it true that I then left your presence? Isn't it true that never once did you tell anyone in the district attorney's office that this incident where you alleged that Thug, DK, and Thug's brother robbed you did not occur?" That includes Miss Love as a witness. She's saying anyone in the district attorney's office. Isn't it true? The only thing we told you you had to do was appear, and I can't understand it. Something about a subpoena. Isn't it true that on May 13, 2013, I had never spoken with you in my life? Did I ask you about Donovan Thomas when we met? And I believe it's at the Wendy's, Your Honor, so Investigator Randolph would be around that area. I have no idea what you heard. Do you remember tearing up when I asked you about Donovan Thomas? So did we talk about him getting killed when you and I met? Did you indicate that it was messed up what happened to him? I didn't, nobody did this. Ms. Love injected herself into the proceedings. There's not a waiver here. She decided to do it on her own. We don't have to sit here and stop her from becoming a witness.
Did you object at the times that she said all these?
There's no objection. She's
By any of you? No. But don't you have to object to preserve the or let the court know at that point in time? Because that's one of the issues that the state's raised, is that you all failed to timely object.
Yeah, the state is wrong. The state is wrong.
Respectfully, because this is not on an appeal where I didn't ask for her to become a witness. The case that the state cites is the contemporaneous objection rule when you want to stop the question. Ms. Love decided voluntarily and freely to interject herself in the proceedings. There's no objection.
No, you still have to
becoming a witness. No,
I disagree with you. You still have to object as soon as you realize that there's an issue, that to preserve the issue so that the appellate court doesn't kind of tell you waiver, right?
But what's the issue?
The issue is what you just told me.
No,
that she's injecting herself as a witness.
And that's okay.
I mean, that's what your allegation is.
That's okay, though.
Okay, but that kind of at least preserves the issue for the court to consider then and make a ruling on it.
The court is considering now, did Ms. Love become a witness in the case?
All right, then the other thing is we haven't completed the examination of Ms. Bennett. So all the conversations, and this is why I asked you to kind of limit as to the conversations that you believe Ms. Love had, and there's no other third party, because you can certainly examine the witness about those particular statements that were allegedly made, or the third party can be examined at some point.
But Okay, sorry.
I'm sorry. That's why I asked you, I'm more concerned about those conversations that you claim where it was just Miss Love and the witness, and she is purportedly, as you said, interjected herself into the matter.
So I gave you two pristine examples that cannot go without the jurors understanding it. The first one is, did you send, this is Miss Love's words, did you send a communication to anyone in District Attorney's Office stating you did not care what the judge said, no one could make you testify, and did you give explicit instructions as to what to tell the judge to do? That is a question. The answer is no. The answer is no. Ms. Bennett said no. So there's nobody else in this planet that I can go to ask, why did Ms. Love say that? In addition, saying to the Honorable Keith Adams' question, there's no witness who's going to come in and testify to that. There's no witness on the witness list. Ms. Love, that's Ms. Love's statement in front of the jury. She has no right. That is a witness.
But what about the when the case law indicates, and you all know this, that statements of counsel are not to be considered as evidence.
But that you cannot do that. When Ms. Love, that's not an objection. That is a statement to influence the jury. There is no witness.
I think a few of you have done that during this trial. And that is just something that it's a practice that is not permitted. It's really not condoned at all, but that you're really not supposed to comment in front of a jury improperly.
Judge, Ms. Love put her own credibility in front of this jury. There is no way to erase it. There's no limiting instructions.
But I'm going to charge the jury at the end of this case that statements of counsel, opening statements, closing arguments, the questions asked by counsel are not to be considered as evidence. They're not.
But Mr. Williams has the right to cross-examine witnesses.
I do. You do. And that's why I'm asking you about the times that she has.
I gave them to you.
Okay, so.
I gave you all those times about telephone conversations. There were just the two of them.
So you're saying the two areas that I'll take judicial notice of, as well as anything that's been on the transcript, and that was on the 25th of March?
Not that I believe. I think it was the 29th. 28th and 29th of March.
28, 29 March. I'll consider those. And then the other ones you point out for my consideration are the communications on the bench outside the courtroom. Is that correct?
Bench outside the courtroom. And then how do you get around the text message when it's not supported by the text message?
What text message? Which ones are you talking about?
When Ms. Love specifically said, and did you send a communication to anyone in the district attorney's office stating that you did not care what the judge said, no one can make you testify, and did you give an explicit instructions as to what you tell the judge to do?
What court, what exhibit was that, or trial exhibit was that was introduced? We need to refer for it to record.
That's fine. That's going to be in all the text messages. I don't know what the state called it, but the question.
Let me just pause a second.
Sure.
Mr. Helsky or Ms. Weaver, do you know what court exhibit, or what exhibit that was? But I need to reference it for the record anyway, so. All right, just give me 1 second, please. Mr. Steele, I'm have in front of me, states 33 alpha alpha, states 34 alpha alpha, and states 35 alpha alpha. If you want to take a look at them, and tell me exactly where it is that, you know, in either one of those three, also have 32 alpha and alpha alpha. Let me take a look at that right quick as you're looking at that. There's also states 32 alpha alpha, which is the, purports to be the text messages from Miss Bennett's son. His phone. Yes, you can, sir.
This is on 34AA.
34 alpha alpha?
Yes. I'm giving them all back.
All right, thank you. Okay, all right.
And the statement made by Ms. Love that I've,
Okay, and 34 alpha alpha?
right, that is the closest you're going to get to.
Which statement are you referring to in this exhibit?
Ms. Love, the one I handed to you, but Ms. Love stated in front of the jury, she testified, and did you send a communication to anyone in the district attorney's office stating you did not care what the judge said, no one could make you testify, and did you give explicit instructions as to what to tell the judge to do? And in the document I just gave,
34 alpha alpha.
that is not even close to a fair summary of what is written by Ms. Bennett. And Ms. Bennett specifically said, no, that is not what I said. And the only person who can be challenged on that testimony, because that's what it was, is Ms. Love. And the state's case that they cited to you, which is Bonner, B-O-N-N-E-R versus State, 192 Georgia Appeal, 721 1989 case, and the state said that this is the only case in Georgia on point. I don't agree with that, but that's what they wrote. And in Bonner, it actually helps Mr. Williams, because in Bonner, what happened was the prosecutor.
What's the citation for Bonner again?
Your Honor, it's 192 Georgia Appeal, 721 386 Southeast 2D 379 1989.
192 Georgia Appeal what? I'm sorry,
721.